Good morning. As always at Bartier Perry, we do an acknowledgement of country. So I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to their elders, past and present, and recognise their continuing connection to our land, waters and culture. I extend my respect to the Aboriginal and Torres Strait Islander people here today. Good morning, my name's Fiona Hoad, and I'm a partner in the family law team at Bartier Perry. I'd like to welcome you all, those that are in the room and those that are online. We have about 30 people online, to this morning's presentation about family law and asset protection. And I'm delighted to introduce you to my wonderful team and colleagues who I work alongside, Madeline Elliott, Chelsea Murray and Catherine Jian, who will be presenting with me this morning. In this morning's presentation, I hope that you leave here with information and guidance as to what mechanisms are available to your clients to protect their assets in the event of a family law breakdown. Last year, I was asked to do a presentation at the Tax Institute, and the topic I was given was the misadventure of the relationship breakdown in family law, which I thought was a very apt description of what happens when a relationship breaks down and collides with family law. The definition of misadventure, according to the Oxford Dictionary, is an unfortunate incident, a mishap, and a mishap is designed as an unlucky accident. And I've been practicing family law for close to 30 years now, and I can confirm that the breakdown of a marriage or a de facto relationship is indeed an unfortunate incident or an unlucky accident. At the beginning of any relationship, when love abounds, neither party can imagine what misadventure awaits, as all that is visible in a marriage is hope and the illusion of forever. Sharing of assets and wealth is a symbol of love and devotion. However, what I've experienced is the willingness to share only exists in the absence of misadventure. Once misadventure arrives, love and devotion makes a hurried exit, and the concept of sharing ends within the marriage. Whilst the law can't protect the marriage from misadventure, there are steps that can be taken to protect a party's assets and wealth from misadventure caused by the breakdown of the marriage. And this presentation explores how this can be done. For ease of reference, when I talk about a marriage, I'm also referring to a de facto relationship because the law applies equally to de facto relationships. So today what we're going to speak about is family trusts and the property test, the bank of mum and dad, so inter-family loans, financial agreements, and some of the tax implications that arise in a family law settlement, and trigger points for advisors, as many of you in the room, or probably all of you, are trusted advisors to your clients. So to start off, I'd like to introduce you to my colleague, Madeline Elliott. What we've done is we've put together a case study that draws on facts of a lot of recent reported decisions to illustrate our agenda, to illustrate what happens in interfamily loans when there's a trust involved, but there's an inheritance and how we can protect assets. So without further ado, I'll introduce you to Madeline Elliott.
Thanks, Fiona. Good morning, all. It's lovely to be presenting to you this morning. As Fiona mentioned, we're going to start with a case study about our friends, Monica and Chandler. And I'm going to give some of those details to you and the background of this case study to set the scene. Monica and Chandler reconnected at their 20-year school reunion when they were in their late 30s. Their relationship moved fast and furiously, and within 6 months they were married. Just prior to the school reunion, Chandler received an inheritance from his grandmother Dorothy of 10,000 Pivot Property Limited shares, which at the time were worth $1 per share. At the time of their marriage, Monica was working as a chef and Chandler was working in his parents' business. Neither Monica or Chandler had any significant assets at that time. Chandler was from a wealthy family, and his parents were generous to Chandler and his 3 brothers, let's call them the Bing brothers. And like they did with the Bing brothers, when Chandler and Monica got engaged, they advanced Chandler $1 million so he and Monica could buy their first home. At the time, they said to Chandler, "We love Monica like a daughter, but this money's for you. And if your marriage doesn't work, we want our money back. Chandler and Monica used the $1 million to buy a 2-bedroom apartment in Parramatta Park for $1 million. Chandler has always worked for the family business, which is called the Bing Group, which operates 6 car dealerships. The shares in the Bing Group are owned by the Bing Family Trust. The Bing Family Trust was established by a deed. It's a discretionary trust settled about 30 years earlier. The original appointers of the trust were Chandler's father, Charles, and his uncle, Derek. But about 5 years prior to the school reunion, Chandler became the appointer, replacing Uncle Derek. The trust deed obligates the appointers to act unanimously. Where an appointer has the power to remove or appoint additional or substitute trustees, no one appointer has control to do so unilaterally, and such decisions must be unanimous. The trustee of the Bing Family Trust is a company called Bing Wealth Management. Chandler and Charles, his father, are directors of the company, and Charles and his wife, Nora, each hold equal number of shares in the company. Chandler and the Bing brothers are primary beneficiaries under the trust, but they have never received a distribution. During the marriage, Chandler worked 6 days a week for the Bing Group, and as he took on more responsibility, the operations for the Bing Group business, he became CEO. Chandler used to refer to the Bing Family Trust as my trust and the Bing Group as my company and my business. Whenever they were short of money, Chandler used to say to Monica, "I'll just get some money from the trust account or from my company." Monica doesn't know if he ever paid that money back. Monica says the trust, which is worth $60 million now, should be included as an asset in the pool and as Chandler's alter ego. Chandler says the trust is his family's, not his, and it shouldn't be included. After the birth of triplets, Rachel, Ross, and Joey, the Parramatta apartment became too small for the family. When Monica said to Chandler, "We need to buy a bigger house for all these kids," Chandler replied, "No problem, I'll just get the money from my business." And so they bought a 5-bedroom house with a swimming pool in Mossman for $2.5 million. Chandler withdrew the $2.5 million from the Bing Wealth Management Company funds to purchase this house. Monica and Chandler did not sell their apartment in Parramatta. They decided to retain it and rent it out as an investment property. And during the marriage, the parties enjoyed a very extravagant and luxurious lifestyle. They went skiing every year. Rachel, Ross, and Joey went to expensive private schools, and Monica drove the latest European 4-wheel drive, which came from the Bing Group car dealerships. Monica assumes that the money that paid for their lifestyle came from Chandler's trust and Chandler's business. Sadly, after 15 years, Monica and Chandler have now separated. At the time of separation, Monica and Chandler have the following assets and liabilities. There's the Mossman home, which is now worth $6 million. The Parramatta apartment, now worth $2 million. Chandler has the 10,000 Pivot Property shares, but now they're worth $5.316 million. The Bing Family Trust is now worth $60 million, and there's this Bing Group debt of $3.5 million. To settle it nice and quickly, Chandler made Monica an offer of settlement. Chandler's offered to transfer his interest in the Mossman property to Monica, and that she pay him $3 million. That he transfers 50% of his Pivot Property shares to Monica. That Monica transfer her interest in the Parramatta investment property to Chandler, and that Monica pays 50% of that Bing Group debt. Monica is concerned. She's worried about the tax consequences of Chandler's offer of settlement, and she's worried about this Bing Group debt. So there's some key issues that arise with this scenario. Chandler says in particular that the $3.5 million drawn from the Bing Group was a loan to the relationship. He says it was company money that funded their lifestyle, and that should be a liability in their asset pool. But Monica says Chandler was entitled to this money. He worked 6 days a week with the company, and if he calls it a debt, then that should be his sole liability. There's also this issue of the $3.5 million withdrawal and what tax implications may come from that. So today we're going to explore some of these key issues, which are, is the Bing Family Trust included as an asset of the relationship? Is Charles and Nora's advancement of $1 million at the beginning a loan or a gift? Are Chandler's Pivot Property Limited shares included in the asset pool, even though he received them as an inheritance prior to this relationship? And what are the tax consequences of Chandler's offer of settlement? So to start with, I'm going to hand over to Catherine, and she is going to discuss family trusts in property settlements.
Thank you, Maddie. So my name is Catherine, and I'm a lawyer in the family law team. And so to start with, we're going to look at when does a trust become matrimonial property? So what is property exactly as compared to a financial resource? So the Family Law Act, Section 4, defines property as property in relation to the parties to a marriage or either of them, means property to which those parties are or a party is entitled to, whether in possession or reversion. And so in Public Trustees and Smith, they say it was perfectly understandable in the context of Section 79 of the Family Law Act that properties of the party to a marriage or either of them should be read as extending not only to property owned by a party, but also to property controlled by one of the parties. And that's where we fall into this issue with our trust. So there are two things that must be considered and have to be found in order for trust assets to be found as matrimonial property. And these two things are control and a lawful right. So control is that a party or the party to the marriage controls the trust or the assets of the trust. And a lawful right means that you have an entitlement under the trustee to actually benefit from the assets of the trust. And so without either of the two being found together, these assets will at most only be considered as a financial resource. And so the key control indicators that you're looking for are somebody is a sole appointer, that you're a sole director or of the corporate trustee, or that you have the power to replace or remove trustees unilaterally. So we're going to look into some cases that pretty much establish the framework and give you an idea of all the areas and factors that can be considered in determining whether a trust actually is property. So the first one we're moving into is Kennan and Spry. So these are the cases. So Kennan and Spry is probably the most established case that most people have heard of. But in essence, the question is, are the assets of this family trust included as property? So to give a bit of background, 10 years prior to his marriage, Dr. Spry established a discretionary trust, but it was only after they were married that this trust was actually formalized by a written deed, so in 1981. So the key terms of the trust are that the beneficiaries were Dr. Spry, his spouses, and his children, and then all his siblings, their spouses, and their children. But importantly, the trust deed provided that the trustee will be Dr. Spry and any other person that he chooses, but he also has the power to remove them at any time unilaterally. They also said that the trustee was empowered in their absolute discretion to apply any or all of the income or capital of the trust to any or all of the beneficiaries. So in 1983, Dr. Spry, through a deed, decided to remove himself as a beneficiary, and instead he appointed his wife, Mrs. Spry, as the trustee in the event of his death or resignation. Now, Mrs. Spry, as his spouse, has a lawful right to benefit from the assets of the trust. When their marriage was going through trouble, Dr. Spry decided to do all these things to try and get rid of this trust from his name, including establishing separate trusts, getting rid of all the money, and saying, look, now that we've separated later, I don't have any money in my name in this trust. But ultimately, the court found that the trust did form part of the assets as property of this pool because, firstly, the trust assets were acquired through the efforts of the parties of the marriage. So the money in the trust came from the two of them and the efforts that they contributed during the marriage. The legal title to the assets were held by Dr. Spry. Dr. Spry made direct financial contributions to this trust, and he was a sole trustee at all relevant times. So notwithstanding that he himself was not a beneficiary, the court found that at any point in time, he could have distributed 100% of the assets to his wife. So his wife really was the one who had the lawful right to benefit, and she was a party to the marriage. And so ultimately, they found that they could undo the fact that he'd gotten rid of the money, bring it back into the pool, and said, we're going to consider this as a property. So that's the first one there. The second one we're going into is Harris and Jewell, in which this case found that it was only a financial resource. So in this case, it was a 24-year marriage, and we're looking at the control and the lawful right to benefits. In this case, in essence, there was no lawful right to benefit. So there was an E-unit trust that was established 5 years prior to the marriage, held assets of about $5 million. The issue was that the wife said this unit trust is the husband's puppet or creature, that he actually controls it, notwithstanding that the person under the trust deed who has the right to benefit is not the husband. So the husband's father was the sole unit holder, but importantly, the husband's father was 99 years old at this time and really was not making any decisions. And so the husband himself conceded, yes, I am the one making all the decisions. I'm the one telling my dad to do these things, sign these documents. And somewhere down the relationship, there was a corporate trustee who became the solicitor, became the corporate trustee, but it was found that the solicitor pretty much took instructions from the husband and not this 99-year-old father. The father owned 67% of the shares in corporate trustee and the husband only owned 33%. notwithstanding that the husband put his own money in, used the money of the trust for himself, and pretty much organized the trust, the court found that under the trust deed itself, he actually had no lawful right to benefit, and only the husband's father, being the sole unit holder of the assets of the trust, had the benefit. And so it was only found as a financial resource, but it was considered, and ultimately there was a 17.5% adjustment to the wife, considering the fact that this husband had a resource in being able to benefit from the trust, notwithstanding that he had no control over it. So ultimately, the court said control in itself is not sufficient. What is required is control over a person or an entity who, by the reason of the powers contained in the trust deed, can obtain or affect the obtaining of a beneficial interest in the property of the trust. And so now we're moving on to Montoya and Rosales. So this one here, the de facto wife argued that the asset pool comprised of property belonging to two companies, being Montoya Proprietary Limited and Montoya Equities Proprietary Limited. And they were the trustee of the Montoya Equities Trust, so overall the Montoya Group. So according to her, the Montoya Group had a combined wealth in excess of $40 million, so very significant assets. And so the Montoya Group intervened. They said, you can't include any of our property in here. It has nothing to do with us. It's not the husband's property. And so importantly, in this case, the constitution of the company stipulated that no director has any special power or casting vote, and each director can be removed or replaced by a shareholder, and that the board decisions have to be resolved by majority vote. And there were only two directors in this company, but both directors have to reach a unanimous decision. So no one person had individual control. However, in this case, this husband has also tried to enter a financial agreement, or a prenup, as we like to call it, with the wife. And during these discussions, he said, this is my asset. These assets of the Montoya Group are part of my assets. They're included in my property. And if we separate, they're going to be mine. And she's trying to rely on this and say, well, he said it's his. He's made representations that it's his. He believes it's his, and he's told me so. So notwithstanding this, the court found that on the balance of probabilities, the Montoya Group was not the alter ego of the husband, and that he was not really a puppet of the group. They said that the structure of the group historically has always required unanimous decision-making, where the various deeds and position appointers are such that unilateral control is not available. And therefore, it was not found that, notwithstanding that he believed and made these representations that subjectively he owned these assets, that it was nothing else other than his own perception, and that's not what reality really was. And so that was not really considered. And so ultimately, the assets of the Montoya Group were not included in the property pool. And so lastly, we're heading into the most recent case, Caldwell and Caldwell in 2025. So for here, the parties were married for 30 years, and then they separated in 2022. The difference between this case is that this trust was established historically as a family business. So it was established 4 generations before these two parties. So the husband had always worked in the Caldwell family business. The business was established by the husband's great-grandfather and be passed down through the generations. And at the time of separation, the business was then owned through a structure of companies and trusts. So importantly, the trust was established by the husband's late father, Mr. K, and it was only to benefit direct lineal descendants of his and no one else. And so after his death, the husband and the husband's 2 sons then became the appointers and principals of the trust, but the husband had the ability, under the terms of the trust, to remove his sons as appointers and principals. So the wife said, well, if case law follows, the only thing you need to show is control and lawful benefit. So the husband has control because he can remove the other appointers and directors of the trust, and he has a lawful right to benefit because he is a direct lineal descendant of one of the trusts, and he can benefit from the assets. And she said that's all that's required, no additional factors. Well, the court actually said, well, that's not really what happens. So control and lawful benefit are the gate openers to allowing a trust in, but then they have to consider all these other factors and consider the reality. In this case, the court said that the terms of the trust were that only direct lineal descendants can benefit, and that the purpose of the trust was to allow the continuation of this business to be run. And it's not to benefit family. It was literally just only so that this business can continue throughout the generations. They also said that the origin of the trust assets were not from these two parties. They didn't actually directly contribute. It was from 4 generations ago and a whole business that has been worked on. And most of the assets actually came from the husband's father. They said that to date, the husband has not benefited from any distributions from the trust, and that there was no evidence that he was a controller. He had no intention to ever remove his sons as appointers, and that he was not acting, that the company was not his sham or alter ego. Further, the husband was actually paid for his work to work in this business, and he was remunerated appropriately. And so, applying the test. So is the Bing family trust matrimonial property? So there are factors for and factors against. Overall, factors that support Monica saying that it is in the pool is that Chandler became an appointer of the trust. He is a director of the corporate trustee. He operated and pretty much controlled the company accounts. He referred to them as, this is my trust, these are my assets, and he funded their lifestyle by taking money out to buy property from the business. And so she argues that it's his alter ego. Now, factors supporting Chandler that say that it's actually not an asset or property is that the trustee requires unanimous decisions. And so his father, Charles, has to agree before anything can be done. Charles and Nina are the ones who hold the shares in the corporate trustee, not Chandler, and that Chandler and the Bing brothers have never received a distribution, so there's no historical benefit, and that the trust predates the marriage by 25 years. And so similarly, under Montoya, his perception of control is irrelevant. He can say that it's his trust whatsoever, but it's not actually his trust. So ultimately, if we apply this, it means that the Bing family trust is not matrimonial property. So what this means for your clients is you always have to consider the trust structure, and you start the way you want to end. So consider the fact that you want to protect these assets. What can you do? You need to consider aspects of control. Who controls it? Can they do so unilaterally, or are there other people you want to include to make sure that there's always a unanimous decision that needs to be made? Is your client a beneficiary? Do they have a lawful right to actually benefit from the trust? And were the trust assets built during the marriage and from each of the parties' contributions? And are there any intermingling of the funds? So are you taking it out for personal purposes? Are you putting your own personal money into the trust as well? And so if you are entering a relationship and you hold interest in trust, the best way to protect your assets is through a financial agreement, or more loosely known as a prenup. So I'm going to move on and I'll pass it on to Chelsea.
Good morning, everyone. I'm Chelsea, and I'm going to talk to you about the bank of mum and dad and whether funds advanced from parents to their children can be described as a loan or a gift. We know that according to 2023 data from Finder's List, parents give their children an average of $33,000 to help with a house deposit. And more than 60% of first home buyers in Australia receive some sort of financial assistance from their parents. The Bank of Mum and Dad is estimated to be collectively worth about $35 billion. As purchasers avoid the top 5 banks and receive funds from the Bank of Mum and Dad, we find that advances of funds are often informal and undocumented. And once a relationship breaks down, the Bank of Mum and Dad want their money back. In family law matters, disputes often arise over whether the Bank of Mum and Dad, the funds advanced from the Bank of Mum and Dad were advanced by way of a loan or a gift. In order to have funds repaid, the courts require clear evidence of a genuine loan, and funds advanced cannot retrospectively be converted into a gift. Or a loan, sorry. In Australia, it's presumed that when a parent advances money to a child, it's a gift which is not repayable. However, the presumption of advancement is rebuttable, and to successfully rebut the presumption, there must be evidence of intention of the Bank of Mum and Dad at the time that the funds were advanced, which demonstrates that the funds are repayable. The court will look at the advanced funds to determine whether the funds are a loan or a gift. And so what does the court accept is a loan? A written loan agreement signed before the funds were advanced that has clear terms of interest, repayment terms, and any security such as a mortgage or a caveat secured over the property. The loan agreement is to be signed by both spouse parties. The spouse parties have made repayments in accordance with the loan. they have acknowledged that the loan is a liability of their relationship on any bank applications or any other formal finance application. The loan is referenced as being repayable to the parents, and in the parents' will, they've indicated that the loan is repayable and that the loan will be deducted from the child's inheritance. And finally, a demand for the payment of the loan is issued upon separation of the spouse parties. Indicators that may suggest the funds advanced are a gift would be that there is an absence of a loan agreement, or the funds have been described by the bank of mum and dad, which indicate that they're not repayable, such as money to help out or simply a gift. If there is a loan agreement, the court will look at whether any repayments have been made in accordance with the terms of the agreement. The court will look at when the demand for repayment of the advanced funds was made, whether it was only made after separation, or if the spouse parties have at some point throughout their relationship declared the funds as non-repayable, for example, when applying to a bank for additional funds. The most common trap for the bank of mum and dad is that there is a limitation period for the enforcement of the loan. A statute of limitations applies to loans from the bank of mum and dad, and the Limitation Act provides that there is a 6-year period from the date that the monies are advanced, or 6 years from when the funds become repayable. If the loan agreement does not specify the terms for the repayment of the loan, then the 6-year period runs from the date that the funds are advanced. If the terms of the loan specify a date for repayment, then the 6 years runs from the date that the debt is due to be repaid. Where the bank of mum and dad advances funds at the beginning of a relationship and does not ask for repayment whilst the spouse child is happily married, when the child's relationship breaks down well after the 6-year period has lapsed, the loan is no longer recoverable. In such circumstances, the funds are treated as a gift. To avoid running out of time to recover loans, the bank of mum and dad lenders should include in the loan agreement a term that does not a repayment term that does not start until a specific period of time has lapsed or a specific event occurs. For example, the loan will be enforceable if the term of the loan agreement provides that the loan is repayable within 3 months after receiving a demand. Alternatively, the loan agreement can provide that the funds are repayable on the sale of a property, and therefore the 6-year period would commence upon the sale of the property. So how can parents protect their money? In addition to an enforceable loan agreement, the bank of mum and dad can insist that as part of the loan, their child and their partner enter into a financial agreement pursuant to the Family Law Act, which acknowledges the loan and provides for the repayment of the loan to mum and dad in the event of a relationship breakdown. The bank of mum and dad can enter into a will that provides for the repayment of the loan from the spouse child's share of their estate. And additionally, they can register a mortgage or a caveat over the property of the spouse child. The registration of security over the spouse child's property is good evidence that the funds are a loan rather than a gift.
So the question is, are Chandler's shares that he inherited prior to the marriage included in the property pool? And the simple answer, along with everything that Catherine and Chelsea have spoken about, is yes. All assets, regardless of when they were acquired, where they came from, are all up for grabs in a breakdown of relationship, unless they have entered a valid financial agreement. The only mechanism available to protect cash gifts and inheritances, undocumented loans, windfalls received by one party to a marriage or relationship is entering into this financial agreement, which is a legally binding contract that can oust the court's jurisdiction to make property orders. Parties can enter into a financial agreement prior to the marriage or de facto relationship, during the marriage or de facto relationship, or even after separation. The financial agreement can set out the parties' agreement in relation to what category of assets can be excluded from any family law property settlement in the event of a breakdown of marriage, what category of assets will be included in a family law property settlement, and it can predetermine how all assets will be distributed in the event of the breakdown of their relationship. So thinking about your clients, what is the best time for them to start considering entering into a BFA? Prior to a marriage or de facto relationship, your client should be considering entering into a BFA if they have any wealth or any business interests, if they're expecting an inheritance, whether in the future or distant inheritance, which is substantial, or they have a trust interest or a beneficiary of a trust, if their parents make financial advances to them or have done so in the past, if they have significantly more assets than the person that they're marrying or getting into a relationship with, and particularly if it's a second marriage and they've already accumulated separate wealth. Not only should it be a pre-relationship consideration, but financial agreements can be entered into during the relationship and become particularly important if one party receives a significant inheritance, gift, or windfall, if there's a particular asset that they want to be quarantined, and if their estate planning objectives require protecting assets for children, particularly if there's children from a prior relationship. Financial agreements can be set aside, and those circumstances can arise if there's been fraud, where, for example, there's been a non-disclosure of assets or financial circumstances prior to entering into the agreement. One of the requirements for a financial agreement to be legally binding is that both parties disclose all of their financial circumstances. If there's been unconscionable conduct, such as where one party exploits the other party's vulnerability, age, language barrier, or inferior position. If there's been undue influence or duress, where the conduct by one party causes the other party to enter into the agreement with the absence of free will. In the absence of legal advice, if one or both parties do not get the requisite legal advice prior to entering into the financial agreement, it can be set aside. And if there's a change in circumstances that is significant, such as if there were a child of the relationship, which would cause hardship to one party under the terms of the agreement. The key takeaway is that financial agreements can be set aside in certain circumstances, and that a poorly drafted BFA may be worse than no BFA at all. Specialist family lawyers and rigorous processes are essential in drafting these documents to properly protect your client's interests. Unfortunately, Chandler and Monica didn't have it in their circumstances, and so it will be dealt with according to each individual asset and the contributions to each of those. And for the last question, I'll hand over to Fiona.
So as part of our case scenario, Chandler did make an offer of settlement to Monica. Monica's very concerned about the implications of the tax implications of that offer of settlement. Chandler wants to transfer 50% of his inherited pivot property shares to Monica. In doing so, he won't be paying any capital gains tax payable. Sorry, he won't be paying any capital gains tax on that disposition or that transfer to Monica because he gets the capital gains tax rollover relief under the Income Tax Act. Monica acquires the shares at Chandler's original cost base of $1 per share, and the payment of capital gains tax is delayed until Monica chooses to sell them in the future, which is something Monica will really have to consider because there'll be a substantial tax liability if and when she does sell in the future. She will get the Mossman property, and the Mossman property will also be, Chandler's interest will also be transferred to Monica. It's a principal place of residence, so it doesn't attract capital gains tax, but it won't be subject to any stamp duty by reason of the transfer because it gets exempted under the Stamp Duties Act. Critical structuring point, what we need to look, we as family lawyers don't provide tax advice. we identify taxation issues arising in a party's financial circumstances and how the implications in any settlement structure. But we then work collaboratively with accountants who have the specialist tax knowledge to assist us in the drafting of orders and the structuring of the settlement in the most tax effective way. In a matter where we are settling, as opposed to a judicial determination, we look at the parties' financial circumstances, their age and stage in life, and where they might be in the future. So it might be okay for Monica to take those shares in the future if she won't sell them, or she intends to sell them, or is likely to sell them at a time when she has limited income, for example. Capital gains tax is a real issue in family law settlements when there is an investment property, because a party who wants to retain the investment property, which is pregnant with a future tax liability, wants the other party to share in that liability. The current position of the court is that you don't share in a prospective or a future or an uncrystallised tax liability. So the reality is that when we look at the asset pool, the net asset pool, we can't take into account any prospective uncrystallised tax liability as a liability of the relationship to formulate the net asset pool. And for the person that is receiving the investment property or the asset that is has that latent tax liability, there is always outrage and a feeling of injustice, because they are in the future going to be subject to a tax liability. And the way the court deals with that is by adjusting the outcome. There's a tinkering provision, which we refer to as the 75-2 future needs factors, but it doesn't have the same outcome and the same dollar for dollar outcome that you would have if it was a crystallised tax debt that was a liability that was factored into achieving the net asset pool that is divided. So what Chandler wants to do is to include it as a liability so that effectively Monica shares 50% of the liability as part of a settlement, but that just can't happen. The other issue is, and many of you will probably have clients that use their company or their trust as their ATM, or where they regularly withdraw money from it to fund a lifestyle. And the issue that arises in family law matters is, how do we deal with that? And if it's not if there isn't a compliant Div 7A loan, then it's this deemed dividend and tax is paid in the hands of the recipient. We again collaborate with our clients' accountants or any of our relationship accountants to work out the best way to deal with a scenario where one of the spouse parties has had their hands in the trough or their nose in the trough, pulling out money to fund lifestyles. And in almost all circumstances, the other spouse isn't aware of what's been happening. So with Chandler, he is a shareholder of the company, but he's a beneficiary of the trust. So he's caught by this associate definition. So there is likely to be there will be a deemed dividend. And what we would do in Chandler's circumstance was say to his accountant, is there any way we can make this compliant? Is there any way this could, perhaps it could be, this money could be flowed through to him notionally through the trust. But these types of consequences are things that are increasingly arising in family law matters, where we need to work collaboratively with you to work out what is the best way to structure a settlement to minimise tax. But also from a trusted advisor's perspective, when you're dealing with your clients, even with their relationship intact, you need to also consider how is this going to operate, or how is this arrangement going to operate should this relationship end in the future? Or if you are aware, and you trusted advisors are usually the first people to become aware of a rocky relationship. We are the last people to become aware of it. We deal with it when it's happened. So trigger points for advisors, as I say, there are things that you can be on the lookout for when providing advice to your clients in relation to their wealth management and the establishment of structures. When you have a client who has adult children who mentions to you that they're going to advance money to their adult child to buy a property, this can be when the adult child is single, so prior to a relationship or during the relationship. Your ears should prick up, because you should assume that, you can assume that possibly in the future they will enter into a relationship. So if a client comes to you and says, oh, listen, I'm going to advance $1 million to my son Chandler, you should probably raise with them a loan agreement. So you start prior to the relationship with a loan agreement, properly drafted loan agreement, that sets out the terms of the agreement, the terms of the repayment, has some interest provisions, and also importantly when this loan is to be repaid. And in those loan agreements, they can be repaid if the relationship breaks down. They can be repaid, or the term of the repayment can be when a property is sold. And those type of clauses in a loan agreement do provide protection. If you've got a client who you know has children who are going to inherit substantial wealth, and if that client tells you that they are going, that one of their children is planning to commence cohabitation or get married, that should be a trigger for you to say, have you considered a financial agreement? Have you considered, or we recommend that your adult child has a look at a financial agreement to protect that contribution, because the difference is real. If it's not protected by a financial agreement, it goes in as a contribution, and the value attached to that contribution is not dollar for dollar. It gets eroded over time. So if you put in $1 million at the commencement of the relationship, unless it's protected by a financial agreement at the end of the long relationship, the adult child doesn't take out $1 million. They might not take out anything. They might just get some credit. It's notional credit when you assess contributions. But what the court has said over the years is that contributions, financial contributions at the commencement of a relationship or through the course of a relationship by way of inheritance or substantial cash injections from family members, are offset by the myriad of other contributions. And the myriad of other contributions can be homemaking, parenting, and also providing emotional and psychological support during the relationship, or just being in the relationship. You get a prize for that too. That's a contribution just for saying I do. So if you want to ensure that future cash gifts or inheritances are protected, then a financial agreement, if you're aware that either your client or your client's adult children are going into a relationship, you should be putting that onto their radar. If prior to a relationship, you're aware that you've got a client that wants to advance money to allow that adult child to enter the property market or whatever, you should be saying, how about a loan agreement? And also, how about your estate planning documents? Because all of those things, when looked at holistically, will support the protection of the asset in the event of the breakdown of the relationship. Trusts as well. If you've got a client who manages their wealth through the trust structure and their children are beneficiaries, we can exclude the trust through a financial agreement only. So again, very, very important to consider that. You'll also get clients telling you that they're entering into a new relationship. So again, I always find that accountants, wealth managers, financial planners are always the first to hear about the new relationship or the breakdown of the relationship. So you are the ones that should be placing these protective mechanisms on their radar. A financial agreement for somebody entering into a relationship for the first time, a young couple, is very different to a financial agreement. It was drafted differently to a financial agreement for parties that are entering into second and subsequent relationships where their asset protection objectives are different. People always come to us saying they want a simple financial agreement, and I'll just put it out there, there's no such thing. Every agreement, we don't just print off a template and fill in names. They are very much bespoke agreements, and they are agreements that are tailored to the circumstances of the relationship as is presented to us. And we must also do a little bit of crystal ball gazing to see, well, what might happen in the future? If they're a young couple, might they have children? Is somebody going to give up a career? And we need to consider that when we draft the agreement and we provide our advice. Subsequent relationships, depending on the age and stage, we have to consider health issues. We have to consider whether, subject to their age, whether there's a possibility somebody might need to enter into aged care. What do we do? How do we fund it? So we need to give all these factors consideration when drafting these agreements. So you'll appreciate that when your client says, look, it's just we're each going to keep our own, we've agreed, he or she will sign anything. Once they get to us, we're not deliberately complicating the situation, but they are complex agreements that need to be properly drafted to meet the circumstances of that party's relationship, and also give consideration to what might happen into the future. Key takeaways. All assets are available in family law. So you cannot quarantine or exclude any asset unless it's already been done so in a financial agreement. There's just no protected category and there's no way around it. Trusts, control alone is insufficient. So again, when setting up a trust and a trust deed, you need to have those factors. You also need to give consideration to the circumstances of your client so that you can consider what appropriate clauses should be included or protective clauses should be included in a trust deed. The trust deed must give a lawful right to benefit, structure trust from the start with a family law matter in mind, regrettably. The bank of mum and dad, if you know your client's going to lend money or advance money, gift money, you need to do it with documentation and do it properly. You just can't convert a gift at the end. And that's what we see in family law, which is why the court's very suspicious and sceptical of parents that come along and say, oh, no, actually, I want my money back. That was really a loan, because it was never really a loan until the relationship broke down. And so the court is, it's very important that the evidence supports that it's a loan. Financial agreements, can't say it enough. It's the only thing you can use. It's the only mechanism available to protect assets. So, and we often hear clients say, oh, I've been told that it's not worth the paper that it's written on. You're better to have one than to not, and to make sure that when you do have one, that you do approach a specialist in family law to properly draft it, and somebody who's experienced in drafting it. The advice is key as well. So the advice has to be about the advantages and disadvantages of the terms of the agreement and the effect of the terms of the agreement on your rights under the Family Law Act. So I always say to clients, there's no point going to the equivalent of Dennis Denudo from the castle, who will review it and go, yeah, this looks like a good deal, or no, it looks like a bad deal, and sign off on the certificate. Signing off of the certificate is prima facie evidence that the advice was provided. But what we're seeing is these agreements can be set aside when somebody comes along and says, well, Dennis just said it was okay, or he said it wasn't a bad deal, but they didn't actually get the advice as to the advantages and disadvantages of the terms and the effects of the terms on your rights under the Act. So what we must do when giving that advice is we effectively have to give you advice about a property settlement, what it might look like in the future based on the asset pool as we know it. So we have to take into account their age, their income. We have to take their current assets, which is why financial disclosure is essential. So you can't enter these agreements without exchanging information about your financial circumstances, your income, your assets, your liabilities. And in a lot of relationships, people don't share that information. And so that is often the bar to not entering into the agreement. And when I give that advice, some clients just say, oh, no, I don't think so. I'll take my chances. But for us to give the advice, we have to know about that information. And so does the solicitor on the other side. If the advice is provided without the disclosure, it's susceptible to a challenge, and a successful challenge in the future. In relation to tax, again, you can identify some tax issues as well for the accountants who would advise on it. And if you have a client who you know is in a relationship or a rocky relationship, and you're structuring their assets or their financial circumstance in a particular way, always have in mind the tax consequences that might arise if this structure is to be pulled apart by the family court, or the asset pool as it's in itself is divided as a result of a relationship breakdown. That's it from us. Has anybody got any questions? Yes.
If you're preparing a BFA for a client, is there a requirement, necessity for the other party to get independent?
Absolutely.
Right.
So if both parties don't have independent legal advice, the nature of the advice, which is set out in the Family Law Act, the advantages and disadvantages, the terms of the agreement, and the effect of the terms of the agreement on their rights under the Family Law Act, they both don't get that advice, then the agreement is not enforceable. And that is where people tend to have a go at setting them aside, or you don't set it aside because it's not, or have a declaration that it's not binding, because one party might get the advice, the proper advice, but the other party might not, which is why when I draft them, I do say to the client, look, I can control the quality of the advice I'm providing you, but I cannot control the quality of the advice that the other party's getting. You need to ensure that when they get the advice, that they do get the advice from a specialist family lawyer who is also experienced in financial agreements. We often provide the names of, 4 or 5 lawyers that we trust would give the proper advice. That's as far as we go in terms of that. And we encourage our clients just to hand that list on, not to do the ringing around for the client, for their spouse or their prospective spouse, just to stay removed from it. You don't want to be. No, not at all. No. Yes.
Might be a hard question to answer, but how much might the establishment of BFA cost?
I do say that they cost about $10,000. That's my rough estimate. Some can cost a lot more. It depends on the complexity of the drafting, the complexity of the asset pool, and the complexity of the agreement. Because the agreements you can enter into a bad deal, you can enter into an unfair agreement. There's nothing wrong with that, and an agreement won't be set aside because it's a bad deal as long as you get the advice. But we encourage people to prepare to enter into agreements that have some element of fairness to it. And so depending on the complexity of the asset pool, we have to draft certain clauses that deal with payments or restructuring of assets or sale of assets. I can say that you cannot have a clause in a financial agreement that says they don't get a payment for infidelity. We've tried it. So people often want that. Anything else, Jerome?
For elderly people in their 60s or 70s, can they just have a BFA that says that neither party will bring any action against the other under the family law code if they're separate because they don't want to share each other's personal information? No.
Because they can't get any advice on it. That's the problem. We can't advise. We have to give you the advice. We have to effectively give you advice on it in relation to how the law would apply to the asset pool that is presented at the time of the financial agreement. And then we advise about what might happen in the future in relation to that pool. So no, that is what a lot of people want is, we'll just sign a waiver, we'll just say we won't. But they do. People do sign those things privately, and when the relationship's over, they do want something.
It said that the loan agreement need to be done before the loans are advanced, but most commonly they've advanced the money, it's a loan in principle and agreement, and they do the documentation after. How important is that?
Depends on the timing. I have seen matters where it has happened afterwards. As long as it doesn't happen around, at the time of the breakdown, that sure, you can do it afterwards and the court will recognise it. Again, as long as it's a loan agreement that stands up.
Following on from that, so we do end up with situations where we say put it through the trust, have a loan in the trust, but if 6 years has expired, can you then sort of, because you've had it sitting there in the trust for over 6 years, can you stick a loan agreement into it after? Obviously not just before a problem, but
After, but before. Yes.
after before, because you've got evidence that you called it a loan.
Yes.
But you haven't got an agreement
Yes.
with it because didn't think of it, wasn't done.
Having a written agreement is best evidence. It's
Obviously,
best, but and not all agreements
A lot
or
of
all
times you don't
contracts
get
are
that.
written.
Yeah.
So again, it will depend on how the parties have conducted themselves as well.
Yeah.
Also, making repayments along the way is helpful. But yet you can, as long as when you do it, it doesn't coincide with.
Yeah, an event.
Yes.
Can you use a repayment? Could be a distribution for the year.
Could be.
Doesn't
Yeah.
have to be a physical,
No.
monetary, because just reduce the loan by a distribution.
Could be. Yeah.
What about re-acknowledging the loan to extend another 6 years on the term? Can you do that?
We could enter into.
New agreement?
You could enter into a new agreement. What happens, what I've seen as well is there's a loan agreement, it's for it, and then it's repaid on the sale of a property. The property is sold and then a new one is entered and the money's readvanced. Yeah. Any other questions?
If you don't have a loan agreement, but you've acknowledged the loan through an entity, a company or trust that advanced it, would that be sufficient in some manner to the court?
So I think the question was, if you don't have a loan agreement, but the loan's been acknowledged through the financial records of a trust or a company, well, it goes a long way. Again, we'd look at all the other factors around the advancement, but it goes a long way to establishing that it's a loan. And if somebody's been signing off on financial statements and tax returns and et cetera in relation to those entities, I think they would have difficulty saying, oh, actually, no, it was really a gift. It's also the way in which the money is advanced. So importantly to your clients, it might not sound important at the time, but when you advance the money, if there's a card saying, dear Chandler and Monica, we love you both and here's a gift and we really want to help you, that's the type of evidence that turns up in litigation to say in support of, well, it wasn't really a loan. So you also want to advise them against just little things like that. If it's a loan, it's a loan. I always say start with a loan, end with a loan. If the relationship remains intact, they never have to repay it.
What we tend to recommend in those cases is say, mum and dad put the money into the trust and then the money flows from the trust to the kids. Whereas if it goes direct, there's always that debate, what was it?
Yeah, that's right. Yeah.
So at least if you pass it through, possibly you got a better chance.
Yeah. Well,
saying it's
if it goes
conclusive.
through as distributions, then it's just.
Not distributions, but just you use the trust or the company as a mechanism to call it a loan.
Oh, okay. Yeah.
You probably, I'd like to think you got a better chance.
As I say, it will go a long way. It would be helpful. Yeah.
Okay.
Any other questions? Well, thank you very much for joining us. It's nothing like trying to protect assets and have a coffee and a croissant at the same time. So I appreciate you taking out your time to meet with us and hear what we have to say. And I hope that you've got some valuable takeaways for your own clients.